The world is changing exponentially. Humanity will see more changes in the next 20 years than it has in the past 300. What we do will change. How we do it, even more so. Be ready. Join the education revolution designed to impact and transform lives. Access 300 world-class programs in over 40 areas of study from over 30 international partners and affiliates in an education ecosystem like no other. Become a future-proof global graduate now. Own your future.
Hello, hi. A very good evening to all of you. There are some of you watching us here on Facebook Live and on Zoom. Thank you so much for joining us. In terms of general so-called classroom management for this session, and to make it an enjoyable session for everybody, for those of you who are watching us on Zoom, welcome. We appreciate if you could very kindly mute your microphones so that way we are able to have a better sound experience. At the same time, if your video is on, please do also off the video because we are going live on Facebook, right? So welcome also to all of you watching us on Facebook Live. My name is David Chang, and I'm with BAC College. And so this evening, we have two distinguished guests with us, lawyers, Alfred and Ivan. Hi, Alfred.
Hi. Hope you can hear me loud and clear.
Yes, very good. Ivan, hello.
Hi.
Hi. Okay, great. So tonight we want to bring together on a table two lawyers in a house for them to share with us more concerning the new measures, the new laws that has been effected recently, and how it affects us here in Singapore in view of COVID-19. And we have Alfred and Ivan, both who are well-established lawyers, to share with us their opinions and comments. And this is by no means a legal advice. They're not here for that purpose. Rather, it's just for them to give their views and comments for us to be more aware. And so in the process of this session, it may be that our viewers here on Facebook Live and on Zoom, in that you may have questions. So we welcome you to type in your questions in the chat box for Zoom, or to type in on the comment section in Facebook Live, and we will collate all the questions. At the end, my colleague Subra, he will come online and join us, and he will assist me to moderate the question answer part in the hope that we're able to assist you with any questions that you may have raised. There's a possibility even that we might not be able to address all of your questions. But that's good, right? So type away, post away, so that we can hear your feedback, and then we might want to then have a series of this, a part 2 or a part 3, in fact. In fact, we have already lined up in advance a part 2 session on Friday. Please do join us one more time. But we actually expect for quite a few new issues that may arise from questions that could arise tonight, and so we may even do a part 3 or part 4, right? So without much ado, I want to just introduce Alfred. Alfred, he is the Managing Director of Dotwell LLC, and he is a very well-established lawyer. In fact, if you read the papers, you'll see his name in the papers frequently for all the good reasons and good things, don't worry. And that's Alfred, right? And he's experienced, and in fact, one of the senior members of the Singapore Bar. With us, of course, is also Ivan. And Ivan, he is a specialist and expert in conveyancing in property transactions. And really in this period, I think we want to understand more of what are the do's and don'ts in the areas of our contracts, as well as in so far as a specific area of conveyancing, property matters, right? So again, I'm David. Welcome to our session of Lawyer in the House. And right now, to just start off by maybe posing a question to Alfred. You know, we have seen a variety of new regulations, and the biggest one, I suppose, would be the new act that was enacted about 2 weeks back. So maybe you can care to share with us in a nutshell what that new act or new law is about, and how it affects contracts and maybe even businesses. Would you care to take the mic, Alfred?
Yes. Well, thank you for inviting me to this series, Lawyers in the House. And you know, we find ourselves almost everywhere around the world, having to interact through Zoom or various other online platforms. And I think it is clear and apparent that we are in a very different paradigm as far as life is, and we may all learn a lot of things. I suppose, you know, the good thing about this is I see a lot of people out jogging and, you know, trying to get fit, because I suppose their gym membership is also suspended, and I hope people will not use the temporary measures to try and get out of bad, ill-placed contracts. But that's where all of this comes in, right? 7th April was a very monumental event in Parliament because the act known as COVID-19 Temporary Measures Act came into power, and it was essential to on the same day by our president, and it came into effect. In essence, what it does is that all of us who have done contract law, you know, and you don't have to be a lawyer to be involved in contracts. We are all involved in contracts in one way or other in our life. So critical areas of contract will need to be looked at in terms of how can this empower one party or the other party as a result of this COVID-19. Because if people, for instance, cannot go out and have their wedding events take place, but they've already booked the hotel, is the hotel going to say, oh, sorry, you are in breach of contract, we take away the deposit, sue them for the full amount? So these are essential practical items. And according to Minister K. Shanmugam, he said during this period, many people, hundreds of letters were going to the Ministry of Law and to, I suppose, various other bodies, pleading with them. What are we going to do? What can we really do? What if I have a vehicle, but I can't go out there and perform my contracts? And what about the hire purchase scenario? And then we have commercial leases similarly. So with all of this in mind, this act has been put into place, and that's where we are at. And we will talk more about this as we go along. Back to you. Can you hear me? Hello?
Hello, hi. Okay, yeah, thank you for that. It may be that I think for us, myself or yourself, the speakers, the broadband connection may break up every now and then. So let's try to think there have been many people who are still uncertain about how things are moving forward because of all the new situation we are in. Just to put to you maybe a very practical, in some sense, a personal question for me, because months ago, in fact, I had made some travel plans for the June holidays, right? Travel. How would you think that would affect the traveler who may want a refund with the hotel or with the airline? Is that something they could claim or ask for travels where large sums could have been paid out?
Okay, there is this lag that's going on. I'm not sure if you're finished, but I will answer that question. In essence, this covers 5 types of contracts, right? And one of which is the exact scenario you're talking about, wedding and travel plans, right? It is a very interesting scenario because weddings, for sure, it is local and mostly local, I'm sure, right? And these laws apply in Singapore. So the idea is for it to be suspended, right? Ideally, you can work it out with the hotel, either to cancel the event, or you can seek to postpone it to a subsequent date, perhaps after October or something, where you can continue with the event, provided availability of the date. So if the hotel, for instance, takes a hardline approach and they said, no, you are supposed to get married on the 19th of May and you are not going to go ahead, I'm going to take away your deposit, then you can go and put in a notification of relief with the Ministry of Law, right? And this is applied also for five categories in essence. One is hire purchase agreements in the commercial arena, right? Not for personal cars, for personal hire and stuff, right? All commercial leases, and then there is this travel and holiday programs. But you see, the scenario applies to Singapore, and if you have booked a ticket for a trip to Bali and a Bali villa, that may not apply as far as Singapore law is concerned. So that is something that you may seek relief in Indonesia, right? And you know, it's beyond our jurisdiction to advise you on that. So it is a tricky situation, and that remains in place now. I mean, let's be brutally honest here, right? As far as Singapore is concerned, yes. Airline tickets as well, technically the act doesn't cover it. So if you're booked to travel and you couldn't travel, right, you might have to look to the airlines, and this act does not support you in relation to these kind of scenarios, but it does in relation to other events and hotel bookings in Singapore. So it covers all these events, and especially weddings events. The other scenario is loans. SMEs especially, they might have secured loans against, you know, certain security measure in place. This is also suspended. And another scenario is, of course, that of bankruptcy, right? Where we have an insolvency. In relation to bankruptcy, from $15,000, it has been increased to $60,000. And insolvency, there is also the scenario where it is $100,000. And by that measure, it also must fall into an event that is affected because of the COVID. So the critical test is, are you unable to pay because of the COVID-19 scenario? That test applies across the board for everything. So it is not just everybody can jump on this bandwagon and say, oh, COVID-19, I'm not going to pay. So there are cutoff dates. 25th March is the commencement date of anything in relation to this. So anything before 25th March, yes, if you entered into it and it's because of COVID, you cannot fulfill it after 25th March for a period of 6 months. Yes, that means this act applies until 19th October 2020. These are the scenarios. Another interesting scenario is that of directors and directors' duties. So in this period, they are allowed to actually continue to trade in relation to the company and the business of the company, even if the company is insolvent. Now, this is a tricky piece of scenario, because usually directors are not allowed. But this does not allow them to trade in matters that allow them to go into fraudulent activities. It doesn't capture criminal activities. So we have found as lawyers that people always try to find loopholes around the law. And even in this scenario, there will be a lot of people who will try to find loopholes around the law. But these are the broad 5 categories or 5 areas and industries where this act actually seeks to provide relief. I hope everybody heard that.
Okay, thank you for that. And I think, as you mentioned, the word that keeps coming up is the word tricky situation, right? And then it's so true. And the other area that I think is also tricky would be that of what we also want to cover today. We'll ask Ivan to share a bit on that. And that would be in relation to property transactions. Obviously, in view of, again, these regulations.
Okay, I also think there's some lag going on, so I am not sure if David has finished his sentence. But I think I'll just jump in on that point regarding property transactions. So when we talk about property transactions, we are actually talking about the performance of usually sale and purchase agreements, and the performance of that essentially is a conveyance of that property from the seller to the buyer. So actually, as regards property transaction or sale and purchase agreements, they are not actually covered by the COVID-19 Temporary Measures Act. As Alfred mentioned earlier on, it only covers and only applies to five big categories of contracts, and contracts for sale and purchase of houses and properties, immovable properties, are actually not covered by the Act. So what happens in this case when it's not covered by the Act, and what happens in practice, is that the solicitors and the lawyers actually take the position that the contract still needs to be performed, but of course there will be difficulties in performing parts of those contracts. For example, when you were to deliver vacant possession of the property, you actually need the seller to move out of their house. So what happens if the seller is not able to move out of their premises? Then that will actually be a breach of the particular contract if vacant possession is not delivered by a certain date. So the position that is taken actually in practice is that the contract still continue to run, and we actually do not have any way to push or actually to force those contracts or to deem those contracts as part of those contracts that is covered under COVID-19 Temporary Measures Act. So we actually proceed to complete those property transactions. But in terms of difficulties that people might face in completing or performing those contracts, there is actually a lot of difficulty that is being faced by parties to the contract, because they actually need to physically deliver cashier's order for payment of the purchase price of the house, to actually take physical possession of the title deeds to the property, to take over keys to the property. So in that aspect, even though the contracts are not covered under the COVID-19 Act, what happens is that the Ministry of Trade has actually allowed or actually carved out an exception for this particular category of legal services, so that the lawyers can actually continue to perform or to assist their clients to continue to perform their side of the contract, so that both sides, buyers and sellers, can actually proceed to actually complete the contract and to take over the house or that property that they are purchasing.
Yeah, if I could just jump in as well. From what I understand, as far as HDB is concerned, that if there are resale applications which have not been registered, HDB will not register any applications and schedule any completions in this current climate, from what I understand. Yeah.
Yes. So what happens is that they will not register the application, but they will allow you to actually file the application for sale and purchase of resale HDB flats. So parties can continue to file the application, both sellers and buyers, to HDB. But what HDB will not be doing is that they will not be processing it. If they do not process them, it means that they will not be able to get the approval from HDB for the sale and purchase. And the sale and purchase will have to be delayed until a further date or later date, where HDB will continue to process and they will start issuing the letters of approvals for the sale and purchase of resale flats. But as for those resale applications that have already been processed and approvals are issued and have already been issued by HDB, what happens is that those completion will continue to proceed, and parties can actually complete and take over the property for those resale flats. But interestingly enough, even though resale applications that have already been approved are allowed to proceed, HDB has suspended all BTO key collection and BTO exercise of option from HDB. So which also means that if you are caught in this very unique situation where you might be required to sell your existing HDB flat when you are purchasing a new BTO flat, you might be faced with this situation where you cannot get keys to your new BTO flat, but the buyers to your existing resale property is actually insisting that they want to complete the sale and purchase of your existing HDB flat. So if that happens, the buyer of the new BTO flat, you may be faced with a situation where you might not have a place to stay for a certain period, maybe a month or two, when you actually are forced to sell your existing flat and you are not able to get keys to the new BTO flat.
But in view of this so-called gap that people may fall within, you reckon that maybe HDB may come up with some further interim measures to sort of plug this gap?
I think for interim measures, I do not foresee that they will actually promulgate anything that will be across board for all parties that are facing this kind of situations. But as with most statutory bodies, they always have the last line there that will say that if you are in need of housing urgently, or if you are facing any hardship, you will probably need to write into them to appeal, and they will probably assess your situation on a case-by-case basis.
Okay, I see. The other buzzword I hear all the time, and these are some of my property agent friends, and they will come up to me and say, you know, hey, David, I hear about this term or concept called force majeure. And I want to just ask maybe Ivan and then later Alfred can take this as well. How does force majeure, this term, come in and sit together with the new measures we have, and how does it affect contracts? Say in your area, say property transactions?
Okay, for property transactions, maybe we don't delve into that yet. Let's talk about force majeure generally. So force majeure is not exactly a creature of statute or a creature of common law per se. It is actually derived from a contract. So force majeure essentially is just a terminology that people use generally to refer to terms and conditions in contracts that allow parties to the contract to defer the time of performance of their obligation, or to actually rewrite their liabilities regarding performance of portions of their contract if certain events were to happen. So force majeure, if you talk about it as a clause, is actually a contractual right for parties to actually rewrite some of their liabilities under contract. So when you want to talk about force majeure, we must be very careful what we are referring to. The terminology actually came from civil law, but in terms of common law contracts, it actually refers to just a contractual term. So if your contract doesn't contain such a clause that allows parties to rewrite their liabilities or to defer their obligations in terms of a crisis like this, then you will not be able to rely on it. You can probably only rely either on the COVID-19 Act if it's passed by Parliament, or anything that's similar to such enactment, or you will have to rely on the common law doctrine of frustration, which can be quite harsh. Yeah. So for force majeure, in the context of property transactions, it is very rare, in fact, for sale and purchase contracts or property transaction contracts to contain a force majeure clause. In fact, the statutorily dictated sale and purchase agreements for licensed housing developers, as well as contracts for the sale and purchase of commercial property directly from the licensed developer or developers, they do not contain any force majeure clause, even though this has been drafted into statute. So it's very rare for property transaction contracts, especially sale and purchase ones, to contain force majeure clauses like this. So if you want to talk about force majeure clauses in terms of property transactions, it will be you will have a hard time finding such a clause to rely on in the first place. Alfred, do you have anything?
Yes,
to add?
I
Yep.
would just add that I suppose many contracts that are well drafted will have a force majeure clause, right, where it's necessary, but it is seldom applied because in context of Singapore, for instance, nobody is going to rely on an earthquake clause or perhaps an act of terrorism for sure. So if there's an epidemic clause, I don't think, perhaps after this pandemic comes and goes, there will be a pandemic clause in almost every other contract. But at this point in time, I suppose loosely, when there is a epidemic kind of scenario, I think people can rely on it to cover the COVID-19 scenario. Okay. Having said that, even if you don't have the clause, I would say that if you are and you don't fall under this temporary measures, the 5 or 6 scenarios, if you are unable to perform a contract due to COVID-19, I suppose you could take this up as a plausible reason for your inability and the reason why you are unable to perform. And I would believe that the courts will be looking at this in a very open-minded manner. Judges in Singapore have a very practical attitude towards things. So I'm sure that even if we don't have a force majeure clause, but if a scenario presents itself where it is clear and evident that the COVID-19 is the reason for non-performance or a breach, I suppose the courts will look at it as to see how you can work things out. So it would be advisable for people in this scenario, rather than trying to find a way out of a contract, to go and negotiate with your contracting party to find a way to find reliefs and extensions and stuff that will enable it to work. So the courts, I am very certain, will frown upon people who take the other party very harshly to court, knowing full well that the COVID-19. So I would advise generally for people who are affected that they should place things in writing, perhaps send an email out to the other party explaining your scenario, why you cannot perform, giving a proper explanation and explaining how you hope to seek an extension of time and how you hope to perform and work things out with them. This is clearly not a force majeure scenario, but I am saying that this is a practical scenario, how you can avoid litigation. I thought I should just add that scenario in. Please go ahead with the next questions, I suppose.
Okay, I think my colleague may be having some problems with the internet lagging, so I'll just jump in. So I'm Subra, I'm also from BAC. So a question perhaps to follow up on contracts of this nature, that those contracts that are affected and they are held in abeyance, if there's any liability in terms of payments and what have you, would there be interest that accrues on these payments during this period?
Now, interestingly, you see, the contract is not suspended. So if the contract provides for an interest clause, it is something that the other contracting party can seek to enforce, right? But because of this suspension, this essentially, this 6 months, what our Ministry of Law and what Parliament has decided is, come on, we are all in this same boat. 6 months, we all should pull this together, right? So during this 6 months, let's suspend all of these things, stop enforcing your rights. Landlords, please don't go and breathe down the necks of your tenants. Hire purchase companies, stop harassing them, right? Let them, give them some relief. They need to earn some money. We, you know, with possibly a recession in the horizons, a lot of things, you know, are at bay. I would believe that you can negotiate with your contracting party, and if all else fail, I suppose if you stand your ground and you go to court, I think the court will also not enforce this interest element needlessly, you know. But bear in mind that the critical cardinal test is, were you affected because of the COVID-19? So that would be the critical element in anything that we're talking about in relation to contracts. I hope that answers your question, right? Bear in mind that there is this panel that has been set up, right? Where you can actually go in and apply for temporary relief, as they call it, COVID-19 temporary relief. It's a PAC, and judges and other parties have volunteered to be in this. Assessor, you can put in a relief for that. Then it will go before this panel, and this panel will then decide on the scenario, and that will essentially be the final decision maker. Courts are negated in this, lawyers are negated, so that they hope by keeping lawyers out of the picture, it can go smoothly. I, of course, disagree, but you know, I'm in the minority. Yes, go ahead. You're mute. I can't hear you.
So just out of curiosity, this proceedings that will be done, so since obviously no lawyers are involved, I'm assuming that no legal arguments to be presented, just purely a form of mediation sort of. Is that what's intended?
Correct. It should be based on just an equitable principles, really, you know, essentially what is fair and reasonable, you know, using Solomon's wisdom to try and sort things out rather than having a purely legal arguments. Because, well, the judges who will preside in this panel already know all these legal arguments. They will know it, but they will still look at where the justice of this case lies. So anybody trying to take advantage of the COVID-19, but clearly was not intending to perform the contract, will not be able to do so, right? So I myself have a case in point now where because of the current, the person is already owing the money from long ago, right? We've gone to court, we've managed to get an order, a judgment, right? And then now with the COVID-19, right, the person knows they cannot pay, and they will probably try to take advantage of this new bankruptcy laws to say, hey, I want to get this buffer 6 months. So I'm planning to test this because I know that this didn't come out of the COVID-19. So I want to test this to see whether it's a catch-all scenario, or it is, you know, again, on a case by case. So I hope to be able to do it, provided the client wants to pursue it, you know.
So it's good that you brought up the bankruptcy. So I understand the new laws have some changes with regard to bankruptcy proceedings.
Yeah.
So perhaps our audience can know a bit more about if someone is to be made bankrupt. Can a bankruptcy petition be presented now? And is it based on whether a COVID-19 event has happened and that's the only reason why it's being held in abeyance?
Interesting test now, because it seems to be a blanket increment to $60,000 from the existing $15,000. That's one. The other is for insolvency scenarios. It is now increased to $100,000, used to be $10,000. And the statutory period was 21 days. So if you give a statutory demand, 21 days later, if the person doesn't pay, you can file bankruptcy proceedings. But now it seems to be 6 months. So it is, it really is an interesting scenario. Me and my team in my office will be studying this scenario because of the case that I have in mind to see where the chips fall. But it could very well be that it is a broad sweep of everybody, and hence those who are also not technically under COVID-19 may benefit from this. You know, the government may want to just say, okay, let's put all of this on hold for now. Let's not start making, because then every case the judges will have to decide, and it's quite cumbersome. If you see the number of people who turn up in court on bankruptcy days, you know, it's quite a bit. So if all these arguments have to be made, it will be a lengthy process. So I believe that it will be a broad 6 months moratorium on all of these things until essentially the COVID-19 comes and goes, you know, passes on.
Are there any arrangements made? I think some people might be like board directors or operating companies, and there would be interesting issues like holding AGMs for a company. Are there any arrangements legally that have been made to cater for this? I think maybe Ivan could answer also if you're aware of this.
So under the Act, if you have a statutory obligation to actually meet, or if you have obligations under certain, for example, Societies Act, and you actually need to meet under your rules or your regulation or your documents of constitution documents, then the Act actually allows for you to actually carry out your obligations without any impact, if you actually were to be able to follow the requirements that is under the COVID-19 Act. So the Act actually allows for parties, for example, directors to meet without the need for them to actually physically meet in a certain location in order to pass their board resolutions.
On that note as well, if we're talking about property transactions, this is signing a sale and purchase agreement. How is that going to be done in a situation like now?
So for the signing of sale and purchase agreement, the Act doesn't say anything much about it, but we know from general law and other statutes that the sale and purchase of immovable property is not actually covered under Electronic Transactions Act. So it means that it is actually a little bit difficult to determine very clearly whether a sale and purchase agreement that's being executed digitally or signed through a tablet with a pen or digital pen actually will have the same legal effect as if it was executed with wet ink signature. So practically speaking, most of the lawyers in practice, we do allow the clients, and we do advise the clients to actually try to sign the sale and purchase agreement by wet ink signature. But what can be done in terms of witnessing the execution of those documents is that it can be done via video conferencing means, for example, via Zoom or Skype, as long as a third-party witness is able to actually physically see the execution or the signing of the sale and purchase agreement. Because once that is signed already, the document can actually be couriered to the witness for the witness to affix their signature so that the whole document is completed. In fact, that is a better position to take in terms of execution of sale and purchase agreement, rather than to take the risk of executing it digitally, because we are not sure whether the law at this point in time actually allows for execution by digital signature. That said, if the sellers or the seller solicitors and the buyers and buyer solicitors have come to an agreement that they will accept the exercise of option by way of a digital signature, then I think that must be documented down in writing, either at least via some email or by WhatsApp, to ensure that this forms part of their agreement and part of the contract in terms of the mode of execution of the option, so that if something were to happen, we have that trace of evidence to show that this mode of execution has been accepted by all parties.
Okay, maybe this may be appropriate time to ask a question that has come via one of our social media platforms. There seems to be a number of questions about the doctrine of frustration and force majeure. So, and I think some of them may need some clarification. What's the difference between a force majeure clause in a contract as opposed to the doctrine of frustration at common law? Could either one of you perhaps
Ivan?
help?
Sure, maybe I'll go first.
Yeah.
Okay. So as I mentioned earlier on, force majeure essentially is a contractual clause. So if you do not find that clause or anything similar to a force majeure clause relating to the liabilities of the party in the event of a pandemic, for example, then there's no way to actually defend yourself by citing force majeure, because that's a contractual clause. So in terms of force majeure clauses, firstly, you need to ensure that there is such a clause inside the contract before you can actually even rely on it. The party that is seeking to rely on it to delay or to actually delay their liabilities or to sort out or to rearrange their liabilities must actually prove to the court or show to the court that they fall squarely within the meaning of the particular clause. So as Alfred mentioned earlier on, following all this, most people will start putting in force majeure clauses with the word epidemic or pandemic inside, but it's not. There are certain contracts that have the word pandemic or epidemic inside, but most of the other force majeure clauses may not have them, or actually I would think that more of them do not have the word epidemic or pandemic inside such a clause. Most, you might probably be able to rely, if you do not have such a term inside, probably rely on acts of God or something along the lines, because acts of God is probably the widest phrase that you can find in most force majeure clause. So in terms of relying on force majeure clauses, you need to find the clause, you need to ensure that you fall squarely within the meaning of the clause, and the courts will actually look closely at the wording of the clause, because most people will list down the events that actually allow them to rely on the particular clause. So most of the time, if you do not find anything that's remotely related to the situation you have at hand, you're going to have a lot of difficulty convincing the courts that you fall within that contractual right to actually delay your obligation or performance of the obligation. And not only that, the courts have also said that in terms of relying on force majeure clauses, you actually need to look and you actually need to mitigate your losses. And you have to ensure that generally the event that you have actually stated inside your force majeure clause and that you wish to rely on is out of the control or generally out of the control of the parties to the contract, which also means that it's both the parties to the contract. So if you are not able to show that that the event you are relying on is actually out of the control of the parties to the contract, then you are going to have a bit more difficulty relying on those clauses that you want to rely on. So, and also what that I mentioned earlier on, you need to mitigate your losses. You cannot just rely on the clause. If the clause is very explicit and you know full well that you are entitled to rely on it, you also need to ensure that you cut your losses, and you need to actually find a certain way of performing your obligations before you attempt to actually go to court to raise this as a defense. If you have not done anything at all to try to perform your part of the contract, or to try to find additional means, even though the additional means or additional methods of performing it might be more expensive, or more cost prohibitive, you need to actually attempt to actually find a way to perform it. If you have not even done that, then the court might not let you actually rely on the force majeure clause. So as regards frustration, frustration is not something that is found in a contractual clause. It is a common law concept that allows the parties whose contract or the performance of the contract will be radically different if they were to perform it at this point in time, or that it is impossible actually to perform the contract. So if you fall within these two general grounds, then you can actually invoke the doctrine of frustration under common law, and you do not need actually a contractual clause to rely on frustration. But frustration is actually difficult, and I would say very onerous on the parties to the contract, because if one of the parties were to argue for frustration and the court actually allows the contract to be terminated due to frustration, what will happen is that generally, of course, subject to the Frustrated Contracts Act, losses will actually fall where they lie. So that may not be the best position that parties may want to see happen. And if somebody were to plead, or one party to a contract were to plead frustration, the contract will be terminated if the court was to accept it, which also means that the contract will no longer be able to continue. So which is why even though the areas of assessment and law appear to overlap between force majeure clauses and frustration, force majeure clauses allow the parties to put some thought into what kind of relief they contractually want to be able to obtain should such an event happen. So you can contractually stipulate how many days of extension you will need to require, what are the relief that you would want to be able to obtain if you actually rely on a force majeure clause. So that allows you more flexibility in terms of contract drafting and in terms of negotiation for that particular contract. But if you actually have to deal with frustration, then you almost do not have any say in terms of what is going to happen once the court finds that the contract is frustrated. So you're not able to dictate the kind of reliefs that you might want to see happen to the contract.
I just want to add that I know many people are frustrated during this period in the pandemic, but the frustration you're feeling has got nothing to do with the legal principle of frustration. So please don't use this clause tonight when you're arguing with your husband and wife and say, I'm invoking the frustration clause in relation to our marriage contract. It's not going to work. I just wanted to add that caveat.
Okay, there's a question.
Oh, as one more scenario, I think frustration can also occur in relation to delay, but this 6 months will not give you the sufficient delay to invoke the frustration clause. So, you know, if the hotel that you booked for your wedding burns down, then its frustration applies, okay? But it's not a scenario where if you and your boyfriend break up, it doesn't mean that, you know, it's an act of God. It's more like, you know, you can't proceed. You're still liable. I just wanted to paint all this scenario because you will not believe it, but in everyday life, a lot of these things happen and people try to use various scenarios. Yeah, sorry, go ahead.
Yeah, there's a question that's been posed here on the Zoom chat, and the question is regarding property tax. I think I think most members of the public are obviously aware of the fact that there's a property tax rebate that the government will be giving back, and they've told landlords to pass that on to tenants. The specific question being asked is, can the landlord pass the property tax rebate to the tenant via installments? Can it be passed back via installments? Is there anything specified in the law in there?
Not in the COVID-19 Temporary Measures Act. So, you know, I can't answer that question. But I suppose what the Ministry of Law is encouraging is people work out a reasonable compromise between parties. So if the government is advising for landlords who are getting this relief to pass it on, then you can work that out with your landlord accordingly.
And again, Alfred, sorry, I got to pose this question to you because this is very specific to the scenario you painted earlier. And this person is asking about burden of proof, right? Does the burden of proof fall on the defendant if COVID-19 is supposed to be shown as the primary cause for non-performance? I suppose if you get sued for non-performance and you are the defendant, do you need to prove that COVID-19 is the primary cause for non-performance?
Yes, the burden of proof will be on the defaulting party who wants to use that as a defense. So you are using it as a defense, then you must be able to plead that as a defense, and you will have to show the evidence to substantiate. So the burden of proof does lie squarely with the defendant, non-performing party.
Okay, whilst Mr. Subra collates some other questions that's coming in from social media, let me just go back to, again, the frustration concept. And just to boil it down to maybe something more practical, we find people selling stuff on Carousel, on Facebook auctions, for example. And obviously now, many of these parties are in some kind of pickle because of these new regulations. So would then these parties, the seller, for example, be able to rely on frustration to then to deliver goods that were ordered online by parties?
Ivan, you want to jump in?
Sure. I think this is not going to be an easy way to argue frustration. So for contracts to be found as frustrated, there is a very high threshold that requires to be met, and it is it's a very onerous threshold for person or for party to actually meet in order for contract to be found as to be frustrated. Firstly, the two general grounds or understanding for contracts to be found as frustrated is that it is impossible to actually perform. Of course, not talking about literal impossibility, but that the contract has been so radically changed such that it cannot be performed, and if it's to be performed, it doesn't go back to what the parties agreed for in the first place to be performed. So one of the examples last time that went to court was that if parties to a contract that was supposed for party A to supply sand to party B, for example, and the parties actually intended under the contract for the sand to be actually imported or to be supplied for a particular country, and that country actually banned the export of sand, so that party A could no longer source for sand from that particular country to actually deliver it to party B. So in that case, I think the court actually said that in such a situation where the parties actually intended and agreed in the contract that the sand to be delivered is actually from a particular country, and this country is no longer exporting sand for export, then the contract is frustrated because the nature of the contract has been so radically changed such that if you were to deliver sand from some other places, that was not what the parties intended to be the core performance of the contract in the first place. So that is a kind of standard that the court is looking at in terms of finding whether a contract is actually frustrated. So in the event the party A and B did not actually contemplate that sand was to be imported or to be delivered from a particular country, but it was just to be sent to be delivered generally, then the court actually did actually mention that in that kind of situation, the court would not have found that the contract was frustrated. So we can see the kind of level that the court is looking at, and the kind of assessment the court is looking at in order to find a contract being frustrated. So if a contract is, or the performance of the contract is inordinately delayed and delayed for a substantial period of time in relation to the nature of the kind of contract, then that could possibly be found to be actually frustrated as well. For example, if a supply of goods and supply of goods from a certain country could not be done because there was war in that particular country. But in terms of carousel and the question that was posed, I think that the delivery of that particular product can actually take place via many other platforms, even if, let's say, you don't use Qoo10, you don't use Grab, or you use any other Ninja van, for example. So if the item can still be delivered, even though it might be more expensive to deliver the item to the consumer, that generally will not be found as a ground to actually frustrate that particular contract. Alfred, do you have anything for that?
Yeah, well, and another, I suppose, very interesting scenario that's happening, not so much in terms of carousel, but I suppose with sports events around the world, if you have booked tickets and it has been cancelled, that in itself is a frustrated contract. For instance, if the European Cup final has been cancelled, then you can get a refund because the contract cannot be performed. Notwithstanding that Manchester United will never make it there for the next 10-20 years, but putting that aside, that frustration is different kind of frustration. Once again, sports events are really the one that is affected around the world now, with a lot of sports event, Tokyo 2020, and a lot of other events have been cancelled. So tickets, I suppose you can get it back. Yeah, sorry, I have to put that in. Yeah.
Yes, and now we know which team you support, Alfred.
One only.
One only. Okay. Okay. I think we want to wind down a session, and again, we are really very appreciative of the time spent by both Alfred and Ivan. Any final words of advice for us, either Alfred or Ivan, concerning what you've shared about this evening before we end our session? Alfred?
I suppose we got to be thankful that our government has taken measures to put into place these temporary measures that will relieve a lot of Singaporeans who are feeling really the brunt of it. What I would perhaps appreciate is a ASEAN level unison in terms of contracts across board, which is where holidays and villas and hotels and stuff like that, so that it can be a bigger catchment area in terms of the unison that we can try and achieve in this pandemic scenario. Because this is not something that we would call upon all countries to cooperate in every scenario, but this is a very unique scenario from historically, seems once in every 100 years or so. So we hope that something of this measure can come into place. Yeah,
okay.
That's what I have in place. Yeah.
Okay. Thank you for that, Alfred. Ivan, any final words from yourself?
Right. For myself, I think personally, the act is a good start, and I think it was a very good move to actually have this act in place and so swiftly, so that people actually know where their obligations and liabilities actually lie. What could be done, of course, essentially, is that for the particular COVID-19 Act, what actually struck me most was that it was, other than supply contracts or construction contracts or event contracts, that you can use COVID-19 as a defense against the breach of that contract. The other kinds of contracts, actually, what the Act actually does under the sections is to actually give a moratorium of roughly about 6 months, so that people are not able to sue on breaches of those contracts. But the idea is that the obligations under the contract still actually run. So what actually came up for me was that this actually is very important for contract drafters, because if the obligations under the contract still continue to run, even though you cannot or you may not be able to enforce them during this 6 months period, then contract drafting is very important. So if you draft in the correct clauses, granting you the relief or granting you the repercussions or the damages, for example, under the contract, then you may you might be able to actually recover those damages or those losses after the moratorium has been lifted. Even though the intention for the moratorium was actually for parties to renegotiate their contracts and to renegotiate their position, it was not for them to walk away entirely from their contract. That was never the point of the act. That was for them to renegotiate such that they can actually come to some kind of consensus for the parties to actually move on with a different set of timelines and a slightly different set of obligations after the moratorium has been lifted. And one of the last thing that I personally thought was also quite interesting was that because the contracts that was covered under the Act, there was a limitation to the time of performance of the contract. I think it was contracts to be performed after 1st February, but contracts must have been entered into before 25th of March or something like that. So it would actually be interesting to see if you have entered into a supplemental agreement to renegotiate or to delay the performance of your obligations after 25th of March, whether those supplemental agreements would still fall under the COVID-19 Act, and you will still be able to serve a notice to actually bar the other party from enforcing their rights under the renegotiated supplemental agreement. For example, if in the event after renegotiating, you still are not able to meet the timelines that you have renegotiated for. So I think that still remains to be seen under the COVID-19 Act.
Okay, that's it. Time is up. Thank you so much, Alfred. Thank you so much, Ivan.
Thank you.
Thank you.
So most likely, we would want to perhaps have a session further on this to expand on some points to have developed. Otherwise, we want to wind down. And just again, thank you to all our viewers for having joined us for the session today. If you are free this Friday, assuming you're not going anywhere, and you can't be going anywhere, do join us this Friday for Lawyer the House on May the 1st, Labor Day. And we want to talk about employment, about workers' rights, about contracts, about criminal matters, social distancing, right? Can you go out? Can you buy bubble tea? More of this to come on Friday. And so with that, thank you so much and good night.
Yeah. Thank you very much for everyone.
Thank you.